Hearsay when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. Whenever you watch any television show based on courtroom drama, you're likely to see one of the lawyers jump up and shout, "Objection! Hearsay!" and then launch into an argument with devastating results to the other side. So what is hearsay and how does it work? Can you object to it? Are the objections a brick wall to stop bad testimony? The actual legal definition of hearsay is pretty easy, although you have to think in steps, which a lot of people aren't used to doing. So hearsay is an out-of-court statement by someone not a part of the suit, sought to be introduced into evidence in court as evidence of the truth of what was said. It's an out-of-court statement, that is, it was made by somebody who was not in court. It's introduced into court, or tried to be introduced into court, and as evidence of the truth of what was being said. The hearsay prohibition comes from the ancient right to face one's accusers, ancient in U.S. and English law. If the accuser, or the person testifying, is allowed to make a statement outside of the sight of the jury that is considering it, without being cross-examined to establish context and believability, you have not been allowed to face your accuser. What if he isn't that smart or honest? With some exceptions, that won't be allowed if it's objected to, but notice you do have to object. An out-of-court statement means that it was said by someone outside of the courtroom in question. It means that the statement was made by somebody who generally was not under oath, although it could have been said in another court under oath, but not in the presence of the people who now need to decide whether it's true or not. Here's a simple example. Jane remarks to a friend one day that guy must be over 6 feet tall. Bob hears her comment and later, while attempting to prove that Joe is over 6 feet tall, testifies that Jane said he must be over 6 feet tall. Can you see how that would be hearsay if the question is whether the guy is over 6 feet tall? Bob is offering Jane's comments as proof that Joe is over 6 feet tall, but the court, or jury as the case may be, can't observe Jane to see whether she looks like she's lying or whether she's serious. And the person trying to prove that Joe is 5'2" can't cross-examine Jane to see if she thinks she's good at guessing people's heights, whether the lighting was good, the perspective was true, or whether that might have been Joe's brother Schmo instead of Joe. So the statement is hearsay if it's used to prove how tall Joe was. But what if it's just being used to prove that Jane was alive and able to talk that day? Then it isn't being used to prove how tall Joe was. Rather, it's being used to prove something that the person testifying can be questioned about and the jury can decide the truth of. So you see that hearsay involves both a statement made out of court and a particular purpose for the use of that testimony. And hearsay can be written or spoken. It doesn't matter which as far as the rule is concerned. Although as a practical matter, of course, almost all writings will have been done outside of court. Now let's take a likely example from the debt law context, although the most common will involve business records, which is a subject for another day. If bill collector, a debt collector, is testifying that he verified your account by calling John Doe creditor when you ask for verification, the statement is not hearsay regarding the FDCPA, Fair Debt Collection Practices Act's requirement that verification be done upon request. But if Bill attempts to introduce John Doe's statement as proof that you do, in fact, owe the money, it's hearsay because the jury or judge would need to see John Doe to decide whether he's speaking truthfully and accurately about you. Here's one final twist to hearsay. It's called party admissions. And no, that's not getting into a party. That rule makes statements made by a party to the lawsuit, even if made outside of court, not hearsay if they are offered against that party. They're just not defined as hearsay. So if you admit to a debt collector that you owe money during an angry phone call, you may hear that statement again in court. But you'll never hear your good lines again, though. That's another good reason to be very careful when you speak to debt collectors. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegalegup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it on YouTube, subscribe and friend me on YouTube, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.